rise for Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are on the record in CV 21-0002. This is Mountainside at Alvey, Flagstaff. A couple of things to keep in mind as we get started. Please remember that these proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. And I know you'll be standing at these podiums, clock's there in the middle. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honor. May it please the Court, Jeffrey Gross, Barry Riddell, on behalf of Mountainside MAR and Trailside MAR appellants. I think that the parties agree on two basic things. One is that this case presents an issue of statutory interpretation that's reviewed de novo. The second, that this Court's role is to ascertain and give effect to the legislative intent. That's the principal role of the Court in issues of statutory interpretation. Parties disagree on what that intent was and how it should be determined. We do know in this case that we have a specific statement of legislative intent. So we know that the legislature intended to provide reasonable limitations on the power of government regulations, so new development and new residents would not disproportionately pay for the cost of new facilities. And the legislature knew that it was going to be tempting for cities to try to shift the cost of new facilities, onto new residents, and that's why there was a statement in the legislative intent that affordable housing is a matter of statewide importance, because they recognize that development fees can affect the affordability of housing. As a result, the legislature adopted a uniform method for cities to set development fees that applies uniformly to all cities, notwithstanding the charter or ordinances. And the uniformity aspect of that was so important that the legislature used the word uniform or version thereof twice in their statement of legislative intent. How was that manifested? Over time, from 1982 to 2011, the legislature adopted more controls, increasingly more controls, to increase the government limitations on city regulations. That was one of the purposes of the legislative intent, over the power to adopt development fees. Now, as of 2020, as of 2011, we have a very, very comprehensive set of limitations on a city's ability to enact, calculate, collect, and use development fees. So what does that tell us about the legislative intent in the context of this case? Well, the legislature, in our view, clearly intended that 9-463.05, the development fee statute, exclusively governed development fees. Well, how do we know this? I want to highlight three reasons. One is simply the express statement of the legislature.
It would help me more if you could point to the exact text, because you've talked a lot about the intent and you've talked a lot about what the law was intended to do, but it'll guide me better if you can show me what text actually supports your argument.
What text in the statute supports
yes.
The argument? For example, the city raises the issue, and amicus raised the issue of the words under this section as somehow suggesting that the legislature was intended to allow a different way of adopting development fees. I think in the context of, in the context of legislative intent, the statement of legislative intent, in the context of the statute as a whole, under this section simply is a different way of saying pursuant to this section. In other words, development fees are adopted pursuant to this section, and then there are limitations. As to specific words in the statute that say this is the way cities have to adopt development fees, I can't point you to any, But when you try to contrast the system in 9-463.05, the development fee statute, with the only other statute that the city has identified as controlling, 9-511.01, the differences are stark. The legislature and this court, not only from the express language of the statute.
But there's nothing in, oh goodness, 946, no.
The development fee statute.
Development fee statute.
Yes.
It says that it trumps 511, right?
There is not, no.
Okay. And there's nothing in 511 that says subject to 840, subject to the development fee statute, sorry.
There is not, and there's nothing in 511.01 that also says this is an exception or an addition to the development fee statute.
So how would we read one into it?
How
How would
do
we read one into it? Because that's basically what the counter-argument is, that 46301 is the exclusive mechanism,
Yes.
again, to the exclusion. So if they
Yes.
didn't include it, how did we read it?
Because the two statutes, the wording of the two statutes really provide that they apply to different situations.
And isn't that what we
9-463.
have here? We have, in 511, we have a statute that explicitly or implicitly says you can charge fees. And you can, doesn't say, there are no explicit limits on the types of fees that can be charged. It says fees. So how do we say that, well, this means that certain types of fees are accepted from this?
A couple of things. First of all, in determining legislative intent, you look at the language of the statutes as a whole. So you have 9-463.05, which provides a very comprehensive system for adopting development fees. And then you have 9-511.01, which the only thing it says, the only thing that you can derive from that statute is the single word fee. And that single word fee is in the context of rate or rate component, fee, or service charge. And I walked through the document, I don't know how to pronounce it.
There are a few more things besides those three that you just mentioned, right? It's not just, I apologize, I don't have the statute right in front of me. But you have, so it's, right, it can be a rate or rate component, a fee or service charge adjustment or increase shall be just and reasonable. So it's an adjustment or an increase, and it's a rate or a rate component, a fee or service. Now, sometimes these fees include things other than rate package. There's the hookup fee, there are other things. So how is it that that's a limitation as opposed to a fairly expansive concept that they can impose a fee?
Because the court, under the Latin doctrine of noscitur scotii, or however it's pronounced, has to read those words together in the same class. And the same class is rate or rate component, fee or service charge. All of those refer to user fees, like hookup fees or connection fees or fire hydrant fees or reinstallation fees or inspection fees. The fees that the cities charge. Pardon?
Fire hydrant fee. Isn't that different in time than a rate component or a service charge? It's more akin to what we're talking about here, which is the meter fee, and based on the size of the meter.
No,
You're adding a new fire hydrant.
yes, but you're adding a new fire hydrant to something that will provide a cost that is an actual user is paying. So it's not a cost to provide, cost to offset providing public services to new development. It's an actual fee that is necessary for the city to provide service to a user, a customer. So those are the type of fees, the user fees, that class of rate or rate component, fee or service charge those are applied to. I would point out that 9-511.01 A1 provides that a city has to prepare a written report or data supporting an increased rate or rate component, fee or service charge. The report or supporting data shall include cash flow projections that...
I didn't see anything in your brief arguing that they hadn't complied with 511.
No, I'm not saying that.
Okay.
What I'm saying is that A1 refers to the overall expenses for providing water or wastewater services. So that's a user fee.
Where I'm getting hung up is you say this is a development fee, and I think you could certainly kind of look at it and say, well, it's a fee that's associated with new development, but why do we have to accept your characterization of it?
It's not my characterization, it's the city's characterization. And the city's characterization was a development fee, first of all, statutory development fee, is a fee that is charged to offset the cost of providing public service facilities to new development. Public service facilities include water facilities, sewer facilities, and other types of facilities. But they're facilities, they're new public infrastructure. The city, in describing this, the capacity fees, and I point you to my chart on page 24 of my opening brief, that's exactly what it refers to. It's the cost of providing facilities.
I'm sorry, not in the ordinance itself. You're saying in the hearings leading up to the adoption of the ordinance, that's how it was described by a city employee. Is that?
And that is how it's used. That's the record, and there's no disputing that. The city has tried to walk back on that a little bit, but there's still no dispute that that is the purpose of a capacity fee. It's to provide facilities to increase the capacity of the water and sewer that the city is providing to that the city is building or going to build or plans to build for new development. And that is a development fee.
It doesn't just apply to new buildings. It applies to buildings that could have been existing for 100 years. If they used a septic system or used a well and they hooked in, then the same fee would apply to them. So it's not just a development.
And that is correct. And the word...
That makes it different in kind, doesn't it?
I disagree, because the word development is defined in 9-463.05, the development fee statute. It's defined in reference to development, as we ordinarily think of it, but also increases in structures or a service unit. And a service unit can be defined as including an expansion of an existing use, increased meter size, the addition of a bathroom. It can be defined as any of those things, in which case the city can adopt development fees to charge that development for increase.
And let me just pick up one thing, which is uniformity.
Mm-hmm.
The rules from 463.05, whichever it is, development fee, very particular rules to make sure that they're uniform and that they're not picking and choosing a deep pocket and hitting them with a higher fee. It isn't the same true under the 511, but those are uniform. Each unit pays the same amount. Depending on the size of the meter, each unit pays the same amount based on the size of that meter as well. Isn't that accurate? So there's no lack of uniformity in what's happening here.
I do not see a uniformity requirement in 511.01, that there can't be different charges. And in fact, and I don't know whether this answers the court's question or not, but for example, the city of Flagstaff actually charges residents who use their water services outside the municipality more than they charge residents
That's the 110%
inside.
rate.
The 110% rate, exactly.
But I think what Judge Goss was asking, and I didn't read your brief as suggesting that there had been a, what's the word I'm looking for? A disparate or a discriminatory, and not in the kind of pejorative sense of the word, but discriminatory approach in your to you all, that you guys were singled out as opposed to how other new hookups are treated? There was-
Correct.
Okay, so
Correct.
that's...
It just goes to the power of the city to adopt it.
Okay.
But let me give you an example of uniformity in 9463.05. Subsection H3, H and H3 specifically say that if a city does not use the development fee for water and sewer infrastructure that has been charged to a property owner, if they don't use all of it or they don't use any of it, then the property owner is permitted to request the return of that fee. That's H3, 463.05 H3. And it specifically applies to water and wastewater. There is no corresponding provision in 511.01. There's no corresponding provision in the city ordinances. So in terms of uniformity, if the city is allowed to charge fees under 9-511.01 and not be bound by provisions in 463.95, such as the requirement to return the fees, then there is no uniformity. And that goes right back to the heart of the legislature's intent in enacting the fee in the first place.
One question, which is, and I'm not certain, well, I don't know, that's why I'm asking. If you have an existing home, that we talked about, and they hook up, are they also charged a development fee?
I'm saying they can be.
Or,
In the city of Flagstaff, I don't know. But I think that the statute,
so
when you look at
it's
the...
different, that the fee in 51105 is recognized as different, at least in kind, than the development fee of the Flagstaff, potentially if they don't charge a development fee to an existing structure.
I'm not sure I understand the question, but oops, I'm sorry. Let me answer it this way, though, which I think is what the question is. The city argues that subsection F in 9-511.01, which deals with connection fees, authorizes their fee, the capacity fee, because it's just another development fee. But the city also charges connection fees, and that's in Exhibit 3 to our appendix of our brief. They also charge connection fees. So they are recognizing, to your point, that there is a distinction between the fees that they're charging under 9-511.01 as connection fees, which is what they're called in the statute, and the fees they're attempting to charge in terms of capacity fees. With that, I'd like to reserve the rest of my time.
Go ahead, Counsel.
May it please the court, my name is Ben Cooper. I represent the city of Flagstaff. This case is the echo of the Ray and Lindsay case that this court handed down yesterday. Justice calling a development agreement an assessment in Ray and Lindsay didn't make it one. Calling a capacity fee, a wastewater or water connection fee, a development fee, in this case, doesn't make it one. Capacity fees are non-discriminatory. I agree
I
with
read
Judge.
that case yesterday, and it's dealing with different statutory...
It is different statutes, that's why it's an echo.
And you filed a notice of supplemental authority?
From yesterday?
Yeah.
No, but Mr.
Okay,
Gross,
then let's move on.
it's Mr. Gross's case, so he well knows it. It's a non-discriminatory, generally applicable fee charged to anyone who connects to a city water or wastewater utility. It's a
Is
level
there
playing.
assurance, if we rule in your favor, that it can be non-discriminatory in the future? I mean, your counsel just posited, the opposing counsel just posited that they could change that. There's nothing in 511 that would require uniformity.
Well, first of all, if you come in to increase a fee, let's say the disparate increase, then that would have to go through all the procedural protections, including just and reasonable, that go into capacity fees under this statute. If he has a challenge based on the lack of uniformity within the capacity fee statute, he can bring that challenge. But that's not what the challenge is before today. The challenge he's brought today is that somehow this was a development fee because he calls it one, because the Mountainside or Trailside happened to be developers. Well, the same fee, the same dollar amount gets charged to Mountainside or Trailside or to an individual homeowner who, without changing their house or changing their operations, moves from a well to city water or from a septic to the city sewer system. It's the same fee.
If that existing homeowner does that, are they also charged a development fee, or is the development fee different in kind?
A development fee is different in kind because it turns on the nature of development. Now, I disagree with Mr. Gross. If you look at the statutory definition of development, it requires this change in structure, not a change in water use, but there has to be a modification of a structure. So, for example, let's assume you have a house that just switches on. There's been no change. That's not development because they moved on. If you had a commercial building that was an infrequently used car wash, let's say, and suddenly became very popular and they needed to draw more water, they may need a larger meter, there's been no development. It's the same existing structures that have always been there. And that's not a development fee. Now, I think as in...
But we're the gas station that adds the car wash.
If they add a car wash, then there could be an argument about whether that's a development fee. But just using more water for an existing structure or moving over to a city system from some individual system does not constitute development. This is a level playing field for anyone who connects, whether they are a developer or not. And this is, in a sense, Ray and Lindsay, like the Georgia and Indiana cases we cited, City of Griffin and Town of Sherrville, which dealt with whether something was an impact fee or development fee, as opposed to some other kind of fee. And it recognized that, as in Ray and Lindsay, the legislature, by adopting, after it had 463.5, it adopted the capacity fee utility connection statute. This was another, the legislature expanded the toolbox available to municipalities that operated systems. It could use a capacity fee, it could impose a development fee. But just because it happens to fall on a developer doesn't mean they get a pass as to generally applicable capacity fees. They have to pay the same fees anyone else has.
So now, using your argument kind of against you, just because you call it a capacity fee doesn't mean it's not.
Well, it's
Why
not.
is it?
It's a capacity fee because it falls under the authorization in 951101, and I'd point the court specifically to F, which says a municipality may not assess or collect a fee on new water or wastewater service connections if, and the only restrictions on that are in F, that is, it can't be used to pay for the cost of acquiring another system's utility function by purchase or eminent domain. That's the only restriction. It directly anticipates that this statute may be used as a way to impose a fee on new connections. Maybe the city could have imposed a development fee. It could have used that mechanism available to it, but it did not. It chose to have a capacity fee that applies to all of the residents and people even outside of the city.
So can we come back to what is the difference between the capacity fee and the development fee? What is it, how is it,
Okay.
what is it different in terms of what it's used for? How is it?
The capacity fee is limited to paying for the costs of operating the water or wastewater utility system. That's what it's limited to. And in this case, it is imposed, it's a targeted mechanism. In this case, it's targeted to both in terms of what it can be used for, and it's targeted this fee to a particular action, which is new water or wastewater connections.
So, as I understand what you just said, it's not putting in a whole new section of the water treatment facility. It's saying, look, now we've got this new user, we're going to have to run the existing facility more, there will be additional expenses.
It can be either the cost of operating the current system or the added capacity required. And that's why, to prevent any disproportionate effect that Mr. Gross was concerned about of development fees, the development fee statute requires the municipality, in setting a development fee, to include the revenues generated from other sources, including the capital recovery portion of utility fees attributable to development. So there's a built-in protection to make sure it's not disproportionate. A city cannot double dip for the same item, one by capacity fee, one by a development fee, the city in this case is charging the same amount to developers and to non-developers. It's based on the operation of their system, and they're entitled to do that. Now, a development fee is different because it can be used for utilities, it can be used for police, it can be used for fire, it can be used for roads, it can be used for a lot of things that have nothing to do with the provision of utility services, of water or wastewater. This water or wastewater statute is a particularized tool intended for one purpose, water or wastewater systems, and their development and maintenance, and that has its own set of procedural safeguards built into that statute. The development fee is in a sense, and it's got a reach that's not only to city residents, but also to any customers of the utility who are outside city boundaries. The development fee is different because it's targeted to all the possible costs of development, and it's got a narrow range. It's only for developments within the city boundaries.
Mr. Cooper, couple questions.
Certainly.
Does the city of Flagstaff assess development fees generally under the development fee statute in other scenarios?
I don't know. I don't think it's in the record in this case whether they do. Certainly, they've not complained that they're paying a development fee. That Mountainside or Trailside haven't claimed that they're paying a development fee, and now they're being double dipped because they have to pay a capacity fee.
Second question, how would you respond to Mr. Gross's, the table that he puts in his brief, alleging that a city employee, when this ordinance went before the city council to adopt, explaining the purpose of a capacity fee, Mr. Gross is saying it sounds awfully similar to a development fee. What's your response to that?
It's an internal report commenting, a city report in 2010, commenting on not at a hearing or any public thing. It's an internal report saying this is what capacity fees are used for, but that's not the determination of what some employee says inside. It's what does the statute authorize the city to do? And the statute authorizes the city to use capacity fees for expansion and maintenance of the water, wastewater and water systems. That doesn't make it a development fee. It makes it a particularized fee under a separate statutory provision. And if the legislature had wanted to subject it to the 9-5-1101 fees to the development fee statute, it could have included a cross-reference. In fact, when it was asked to do that, there was a proposed amendment to do that. The legislature turned it down.
How much weight should this court give that?
I think, Your Honor, it confirms what the plain language says, that if the legislature had wanted to link the two statutes together, it would have done that. If the legislature had wanted to have one set of procedures, it could have done that. Instead, it has one set of procedures for a capacity fee, a connection fee under 9-5-1101, and has a separate set of procedures for development fee. The court can conceive of this as like a Venn diagram, that in terms of purpose, how you can use the money, there's separate things on development fee, there are separate things on a capacity connection fee, and there's an overlap where the city has, to use the language of Town of Florence and Ray and Lindsay, an expanded toolbox it can use to raise funds for a particular purpose. And as long as it complies with the terms of one of its authorizing statutes, that's lawful. And what Mountainside and Trailside are saying is, gee, we're developers, so the only way you can impose a fee on us is through the development fee statute. That's not correct. They can be subject to all of the fees imposed under the other authorizing statutes, in this case 9-5-1101. And that is...
I'm sorry, go ahead.
I'm sorry, no, go ahead.
No, you finish your sentence.
No, that is specific to water and wastewater, and in this case, connection fees. And that's a separate statutory authorization. It doesn't matter that we could have used a development fee, in which case we would have been subject to those other procedural requirements. The fact is that there was an authorization that specifically met the city's needs to impose a connection fee, and that's what it did.
Let me pose kind of an absurd hypothetical, but to me it seems to be very telling. Is it theoretically possible that someone could build a large apartment complex or even a small apartment complex and still do it and receive all the necessary approvals without hooking up to the sewer system and the water system. They'd sink their own wells,
Absolutely.
build their own septic tanks,
You
right?
know, I guess I live in a area of this metropolitan area where I'm on septic. I could fully imagine that before there were sewer systems, there may have been hotels or complexes that were on wells or on septic tanks, series of septic tanks, and could have done it. They maybe have been subject to a development fee to pay for the roads going to them, but there wouldn't have been a new...
But that wouldn't be an issue here. So someone, a developer or anyone could build something and sink their own wells and do their own septic system and would not be subject to this fee.
would not be subject to a capacity fee. But on the other hand, you could have people who are subject to capacity fees who haven't done any development.
Right.
Because it's not a tax, it's not a fee imposed on development qua development. It's imposed on new connections, regardless of whether there's development.
So like you were talking about earlier, someone who may have been on a septic and decides, I'm tired of pouring that stuff down the drain every 6 months, I'm going to hook up to the sewer system, they would be subject to it, even though it's not a new development.
Exactly. I would be subject, if I were, where I live, I might be subject to a capacity fee if I hook up my septic to a city sewer system. But, that's why they're different things. There's no overlap. You can have development without connection, and you have connection without development. The fact that they happen to be a developer who connects means they could be subject to either fee. In this case, the city relied on its ability to apply the same, I think it's somewhere around $3,200. That would be paid by someone,
I tried to do the math on that. It seems like the $3,200 is maybe just the sewer fee, and then there's a separate fee for the water, and that's how we got.
I forget the exact math.
3,200 times the number of units did not come up with $1 million.
Right.
37.20.
But it's the same number that's applied, whether or not it's an existing building that hooks up or a new development, based on the unit.
There was some indication in the record, I can't remember if it's from the prior case or this case, but that the city was withholding the permits on them until they paid it, right? But that's because it wasn't habitable until you actually have a sewer system. It wasn't that they were...
That's correct. I mean, there are, those are all development requirements, and they're really, all the requirements for bringing housing online, having to have water or some kind of sewer capacity. But that, or wastewater capacity, but that's not really the issue here. The issue fundamentally here is that Mountainside and Trailside do not want to pay the same kind of fee everyone else would pay for their new connection to the system. And their explanation is, well, we're a developer, and therefore the only way you can charge us is through a development fee. And that's not correct. If the legislature wanted to do it that way, it could have done it that way. But then you'd have uniformity challenges by non-developers who say, why don't they have to pay the same fee we do? The fact is, I believe that, in fact, that there is no development fee because they said there would be no system requirements added by, extraordinary requirements added by their development. So I don't think they did pay a development fee in this case.
Well, there could be something for roads or something else, but it's not.
Right, it was not for here, and that's why development fee is a much broader tool, and that's why there's a concern about the fairness and uniformity of the process for adopting them statewide. Here, because these same fees apply, capacity fees apply to not only to developers, but to other users of the system, if there's a problem with the amount of the fee, like it's excessive or something like that, when they go to public hearing and have to adopt an increase in the fee, you're going to have all those other people who are not developers coming in. That is, the protection comes from it being a generally applicable fee that everyone has to pay.
Well, that in this case is relatively limited. I mean, well, maybe the record doesn't show this, but I would imagine that the overwhelming majority of capacity fees are charged to new hookups. So it's probably rare that you have someone who's switching from septic to sewer or et cetera.
It could depend on the year. It could depend on the period of time you're going through. You could have a period where no one's building new developments, but there's an issue with private wells or septic tanks, and people are switching over. So there's no guarantee that in any particular year there'll be a particular balance. The key point is that everyone is subject to the same fee based on the same principle, that is, new connections, regardless of and that's what brings us within the scope of 951101 as the authorizing statute. And, Mr. Gross's challenge is showing why that statute does not fit the facts here. He hasn't done that. He simply insists, we're a developer, so therefore it has to be under this other statute. And the teaching of Ray and Lindsay is, it doesn't. You could have multiple tools that a local government can use to raise revenue. And as long as you comply with one of them, it's a lawful imposition. Now, my last...
I want you to, and I appreciate you're running short on time. Council suggests that the word fee in 51101 is limited by the words around it, that it needs to relate to a rate or a rate component or service charge, and that this fee somehow doesn't fall within that. How do you respond?
Well, now he's relying on not to do associate, which I believe is the correct pronunciation. I've looked up 12 times. But that doesn't apply when you're dealing with a listing. What he's really trying to argue when he said that it's a rate component fee is the doctrine of series qualifier canon, which says if you have the SIG at the beginning, it applies to all the elements. Except that's a very contextual canon, and it has to make sense as applied to all those other things. So rate component fee is a term that doesn't exist. I did a Google search. I couldn't find it and a Westlaw search. It doesn't exist. There's no such thing as a rate component fee. There is a rate or rate component. There is a rate component, as outside another court that uses it, is a component of a rate. And you have fees and service charges. They're all things that are related to each other in that they're all things that are charged to people, whether it's a rate or rate component or a fee or a service charge. There's no violation of Dasser Associae by saying that somehow they have to be related to each other. They are related to each other. We're dealing with a fee charged to a user of the service, but there's no fit to that. But what he tries to do is say it has to be an adjunct to a rate on the principle that it's a rate component fee. But you can't use that canon where the result is kind of nonsensical. And I think Scalia and Garner say that. We cited a host of cases saying that those canons don't, they're secondary. And in any event, they only apply when there's some ambiguity. Is there an ambiguity to fee? Well, subsection F says you can have a fee on new water or wastewater service connections. What's the ambiguity? That's one of the kinds of fees you could have. I give due credit to his creativity, but there's no need for creativity here. There's a fee, and fees are authorized. And, I think we're at the end of the analysis that's required under this statute. Unless the court has any other questions, I'll sit down.
Thank you, Mr. Cooper. Mr. Gross, you've got a little over 3 minutes.
Yeah, thank you. Let me address that last point really quickly. I am not relying on the series qualifier rule. I'm relying on the words that are construed together. And so I don't care about rate component fee, however he tries to portray it. Its fee has to be considered in the same category as a rate component, or a service charge. Those are user fees. Service charges get charged to users, rates get charged to users, rate components are components of rates. Fees fall within the same class. They're the limited fees that cities charge in connection with the use of water or wastewater.
Explain that to me. Why isn't this, okay, so let's say it has to be like a user charge. Why isn't this a user charge for a new
Because it's not, and that gets to my second point I want to make, which is Mr. Cooper acknowledges that their capacity fees are two types. I mean, this is what he says. There are two types. One is maintenance and operation of the system. The second is addition of new facilities. We know it's addition of new facilities because that's what the evidence is in the record. There's no evidence in the record to say that it's operation and maintenance. So they are charging for facilities, new facilities. That's not a user fee. That's a fee to build new stuff because of new development. That's a development fee. Whether they try to bundle them in the same package as, okay, we're going to charge for operation and maintenance here, and we're going to charge for new facilities here. The fact is that Mountainside paid $1.5 million for new facilities. That's what's on the record. That's what was in front of the court. And new facilities are charged for new facilities to offset the cost to the municipality of providing new public facilities. That's a development fee. Doesn't matter whether they try to bundle them into the same, put them in the same bucket and distribute out money here and there. If Mountainside and Trailside are paying $1.5 million for new facilities, the legislature made it very clear we want a uniform method for charging property owners the costs to offset providing new facilities, new public service facilities to new development.
One of the things I'm having a hard time with on your argument is the fact that the legislature, we mentioned all the cross-references before, and how come they did or whether they had cross-referenced. They actually were presented with and considered a explicit cross-reference, which would resolve all that ambiguity or lack thereof in your favor, and rejected it. So what are we to make of that?
Well, I think you're to make the same exact thing the Supreme Court made of it in, I believe it's the City of Flagstaff versus Magnum case, which was, it's equally plausible, and I would submit more plausible, that given the legislative intent in 1982 to adopt a uniform method for enacting development fees, and the language, the very limited language in 9-511.01, the legislature simply said, we don't need this. We already made it very, very clear that this is the section that applies to development fees. It doesn't matter. We don't need to put this in and make things and clarify what we already said in 1982. So I would ask that the court overturn the trial court's ruling and remand it for entry of summary judgment in our favor. Thank you.
Thank you. Counsel, we thank you both for your written briefs, for argument today. You've given us much to think about. We'll take the matter under advisement and issue a written ruling in due course, and we are adjourned.